Okay, and it is 10 after, so I think whenever you're ready to start, David, you should begin.
Okay, thank you. This panel, if you haven't heard, so the 3 of the 4 speakers are here. The 3 of us are all colleagues at Tel-Aviv University. The 4th speaker, Jessica Apolloni, is not feeling well, and so will not be joining us today in the panel. So there will just be 3 of us, which gives a drop more time. We also want to leave time at the end for questions, answers, discussion. But what we'll do is we'll each speak in turn following the order and the program that was sent out today. And we could also take maybe 1 or 2 questions after each talk if people have. And if people prefer to wait till the end to ask, that's also fine. Because we should have time at the end. Okay, so I've been appointed the chair of the session, so I will introduce the speakers as well. So I'll start with myself because I'm going to go first. So I'm David Schorr, and I teach law at Tel Aviv University. And currently working on major topics that I'm currently researching are the history of water law and the history of the transmission of legal norms in the British Empire. And the paper that I'll be giving today actually sits at the intersection of those 2 topics. So let me jump right in. Let me share my screen actually. 1 second. And there we go. Can you see the slide now? Okay, good. So my paper is on the history of a comparative way of thinking about law. And what I'm interested, you can see from the title is Nature versus the Common Law, Nature as a Norm in the Water Law of the British World. And what I'm interested in here actually is not whether nature or the environment or climate actually changed the law in some way. I'm actually personally skeptical of deterministic claims that somehow nature or climate determines legal norms. The subject of this paper is judicial rhetoric, really. And I'm interested in cases in which courts argued that the law changed or that the law must change as a result of natural factors. And this paper is actually, there we go. It's the written version is a forthcoming article in a French legal history journal, and the topic of the issue is nature as a norm. And so that's the focus of the article here: nature as a norm in the context of water law. And as I said, this sits at the intersection of 2 of my interests: history of water law and the circulation or transmission of legal norms in the British Empire. And just by way of introduction, so the other 2 papers today are also talking about the British Empire. That's the organizing theme of the panel. So as I'm sure everyone knows, the British Empire was an extremely widespread empire with territories all around the globe, but also very much in the consciousness of people who thought about, contemporaries who thought about British Empire, was the fact that the empire was very diverse from an environmental perspective, right? So here's a stanza from Kipling's Recessional, where he talks about dominion over palm and pine, right? The reference being to palm, the tropical empire, and pine, presumably the North American portions of the empire. British are very aware of the fact that the empire is very diverse from a physical, geographical, environmental point of view. So my talk today, I'm going to discuss 4 legal issues The first is who owns the river. Second is the issue of shifting water courses. Third, damage from escaping water. And the fourth, diversion of water from water courses. And in all of these, I'm going to be looking at cases in which courts around the British world, I use the term British world to include the United States as well, even after it had left the British Empire, cases in which courts basically say the environment here is different than the environment in Britain, and therefore the water law has to change as well. And so the first topic is, which I'll spend also the most time on, is the issue of ownership over the river. And by ownership over the river, I mean the water itself, the bed of the river, the fish in the river. These are all things that might be owned by riparian owners, meaning people who own land on the banks of the river, or they might not. They might be public and belong to the public. Now, the traditional common law rule, as expressed in Hale, is that tidal rivers are the property of the Crown. So the tidal estuaries, let's say, of the Thames up to London, more or less, belongs to the Crown, and above the tidal parts, or in the context of the eastern seaboard of the United States, above the fall line, the rivers belong to the riparian owners on either bank. Each one owns the water and the bed up to the median line of the river. And the earliest case to sort of question the common law, at least the one earliest that I've come across, is this 1807 case from Pennsylvania. At issue was the issue of fishing rights in the Susquehanna River near Harrisburg. The river at that point is not tidal, but it is quite navigable at that point. It's very wide. So according to the traditional common law, the river and the fish in it should have belonged to the riparian owners on either bank. But the court here, Pennsylvania Supreme Court, ruled that the river is public, despite it not being tidal at this point, rejecting the common law rule, so anyone can fish there. And you can see here the reasoning of the court. They say the Susquehanna is a mile wide, runs several hundred miles through a rich country. It's navigable and actually navigated. It doesn't make any sense to talk about this as a private river. If it had existed in England, the English rule would not have applied to it. And so the Pennsylvania court strikes off in a new direction. Now, this set off a wave of similar cases all around the United States at the time. So just another example is this case from New York. And a regular feature of these cases, as you can see in this example, is their listing of the great American rivers. So here they list the Mississippi, the Ohio, the Susquehanna, the Niagara, and the St. Lawrence. And this becomes a sort of litany, which is repeated in many of these cases. And it's often funny to actually see which rivers are added to the list, some not so great. And another semi-regular feature of the cases is the denigration of the pathetic English rivers, which you can see in the second paragraph here. Sorry, not the second paragraph, the beginning of the first paragraph, where they say, it is a matter of just exaltation as well as benefit to the country that in the United States, we have rivers which are above tide, are navigable to a greater extent than would be the circumnavigation of the United Kingdoms of Great Britain and Ireland, right? So the Mississippi or the Missouri are longer than the full circumference of the British Isles. I don't know if it's actually true, but that's what they say at least. Now the lawyers in this case argued, they were even more insulting. They said, can the English law extend to our large rivers, lakes, inland seas? Their waters gathered would form a mighty ocean into which were the whole land of the common law cast. And if we were to throw all of England into our waters, a ripple on its surface would be scarce produced. So all the waters and streams of Great Britain diverted into the Niagara would cause no perceptible excession. Right? So this is the way that they like to talk about the British waters as opposed to the American ones. Now this type of thinking spread to Canada. And now Canada is caught in between England and the United States. They're part of the British Empire. And outside of Quebec, they're committed to the common law, but they share a continent with the United States. And the first Canadian cases that considered this the American approach rejected it, saying that and one case says, for instance, that to change the law for policy reasons is best left to the legislature, not to courts, as you might expect. But in an 1852 case, an Ontario court contrasted the English precedents with those, quote, from this side of the Atlantic, right? So lumping the American and Canadian precedents together as opposed to the English ones. And then this case you have in front of you, also, very oddly to my mind, says the English rule does not apply to the great rivers of this continent, as has been determined by the Supreme Court of the United States and by the courts of most of the states. In other words, so the Supreme Court of the United States and the American state courts are legal authority for the continent in a way that English courts are not. And then this case from India takes things a step further, and they look at this Indian case cites the American cases, including the old Pennsylvania cases, and says that American law applies to India not because they share a continent, right, which they don't, but because the rivers of India are more similar to the rivers of the United States than they are to the rivers of England. Now, I want to point out that not all courts went along with this approach, right? So again, I'm trying to push back against the deterministic view. It was purely a choice that the courts made. And so here's an early example of a court, New York court, rejecting this way of thinking, saying, I do not myself feel authorized to reject the principles of English common law by saying they are not suited to our condition. And this case from Ontario from the early 20th century, which sort of pokes fun at what they call spread eagleism, right, or legal jingoism of the Americans and of the Canadians as well, right, poking fun at the patriotism that's evident in much of these of the case law, right, and saying basically, the inland waters in the UK are not really so pathetic, and then sort of making fun of some of their own Canadian water bodies, which are actually not so magnificently large. Okay, so that's the first topic I wanted to cover. And by the way, Assaf and Ron, I'm not keeping time for myself, so let me know when I'm getting close to time. The next set of cases has to do with shifting boundaries between water and land, the doctrines known as alluvion and dereliction of a river, and so on. And the distinction in the common law, basically there's a distinction between gradual changes, which basically accrue to the existing landowners, and more drastic, sudden, catastrophic changes, which don't. And we'll start with the Privy Council case coming up from southern Nigeria. And it was argued in this case that the English law of accretion does not apply in southern Nigeria. And the court here, following the lower court, says that English rules do have general applicability, or we have no reason to doubt the general applicability of English law here. Nonetheless, just a year earlier, actually, we have a completely different approach taken by the Privy Council. And in this case, the Indian courts had been taking a different approach for a while, and often pointing again to the similarities between Indian and American rivers. This kind of argument first came up in an 1872 Privy Council case, in which this comparison was made. In an 1899 case, the Privy Council, without ruling on the topic, noted that it had grave doubts whether the presumption applicable to little English rivers applies to great rivers such as the Godavari. And then the leading case is the one you see before you, Srinath Roy, in which the court doubts the applicability of English rules developed for small English rivers to the great Indian rivers, right, and particularly in the lower, in the Bengal Delta, the Delta of the Ganges. And they say, but what analogy can rules applicable to the Eden and the Lune, right, two small rivers in northern England, apply to such physical conditions? And perhaps more interestingly is this quote from the same decision, in which the court attributes not only agency to the river, right? Those of you who follow this field of law may know that there was a decision a few years ago where an Indian high court said that certain rivers in England have legal personality. So the court here, the Privy Council, seems to be doing this 100 years earlier as well. It says, it is the river that has made his land its own, the water, and so attributing agency to the river, but legal agency as well. And right now I'll read, it is the river that has made his land its own. The waters are the tidal navigable rivers of the great stream. In physical fact, the landowner enjoys his land by the precarious grace of the river, whose identity is so persistent and whose character is so predominating as almost to amount to personality. And is it fundamentally unjust that in law too, he should lose, meaning the landowner should lose what he has lost in fact, and be precluded from taking in substitution for his lost land an uncorporeal right, which has been granted not to him, but to another? So notice the court here is saying the river has decided to take the land from one landowner and give it to another landowner. Who are we, the court, to argue against this legal decision of the great river who has decided for us? Okay, so that's the second topic. The third topic is the damage from escaping water. And those of you in the common law world are all familiar, I think, with the rule in Rylands versus Fletcher, and in which the rule here depends on what is considered a natural land use and what is considered unnatural. And the English courts that ruled in the case ruled up to the House of Lords, ruled that bringing water onto land was a non-natural use, that therefore if the water escaped and damaged the neighbor's land, the defendant was strictly liable, even in absence of negligence. Now, the Madras Railway Company immediately engineered a test case in the Madras courts, intending to appeal it all the way up to the Privy Council, which they did. And what they did is they engineered a case where the railroad had been damaged by the escape of water from irrigation tanks from reservoirs in India. And rather than claim negligence on the part of the landowners, the court refused to allege negligence and rested their case basically with no allegations of negligence, trying to get the Indian courts to say that Rylands versus Fletcher applies here in India as well. And the reason the railway wanted that was because sometimes the rail was damaged by escaping water, and they wanted to be able to receive compensation without proving negligence. And so here's the quote from the High Court of Madras on the first appeal, which says that basically the environment changes the law. So maybe in England, they said in England, storing water for irrigation is a non-natural use. In India, we can't think of any more natural use. So the rule in Rylands versus Fletcher applies in India, but it applies in a different way. What's considered a natural use and what's considered non-natural use changes from place to place. And one of these days, I'm going to look at Rylands versus Fletcher across the British Empire, because the issue comes up everywhere. But for now, I'm just going to make do with this Indian case. And then the last topic I want to briefly touch on is the diversion of water. And I'm going to focus on diversion of water for irrigation. And the common law rule is once again notably based on the idea of nature, of natural law. Basically, the rule is an upstream riparian may not divert a stream's water to the unreasonable detriment of downstream owners. And this is couched in the classic cases in terms of jure naturae, right? The idea that there's a natural right to have water flowing as it had flowed. In the Western United States, diversion of water from watercourses was necessary for mining, for irrigation, later for industry and water supply. And courts came up against this question about whether the common law applied. Now, this leading case from California, Lux versus Hagen, they refused to change the law. And I think in very interesting terms, right? What the court here says is that changes in political conditions do change the law, but changes in environmental conditions do not change the law, right? So since the American Revolution, they say that there's new political conditions that does change the law. Things that do not harmonize with our new democracy do not apply in the United States. However, climatic or geographical conditions do not operate to change property rights. So that's the California court's leading decision. Other states went in a different direction. So Colorado, which I've written a book about, this is the first case in Colorado that deals with the question. And the Colorado courts consistently say no, nature does act to change property rights. So just read a little bit here. The principles of the Decalogue may be applied to the conduct of men in every country and clime, but rules respecting the tenure of property must yield to the physical laws of nature whenever such laws exert a controlling influence. And then it goes on to say, in a dry and thirsty land, the law has to change. Water law has to change. And in a later California case from 1903, this is the big California precedent on groundwater, on ownership of groundwater. And here, the California Supreme Court, the next generation of the California Supreme Court, again goes in this direction and rejects the common law based on environmental considerations. And this case gives a long dissertation on the geology and climate of California, particularly of Southern California, and how necessary irrigation is, and then goes on to say that common law rule cannot apply here. It would tend to injustice and wrong, and so justice requires a different rule be adopted, and they reject the common law rule of ownership of subterranean water. So those are the four issues, and just to finish up, so basically what I've just tried to show here is that courts, in many cases, were not bound to have to take environmental considerations into account in changing the law, but they often did in a variety of contexts and in a variety of jurisdictions. And just before I finish, I just want to address one last question: why focus on courts and not legislatures, for instance? So here's a picture of an irrigation works in Southeast Australia. And Australian states, like other jurisdictions such as Western Canadian provinces, also abrogated riparian rights to allow diversion of water and other departures from the common law of water. But they did so through legislation. So Australian courts, actually, this came to Australian courts a couple of times. Australian courts refused to change the law, and the legislatures there changed the law. And I've intentionally ignored those kind of changes in the law in this paper because they also clearly were responding to environmental considerations. However, they were enacted to the power of legislatures, and to my way of thinking at least, that gives nature less normative force. In other words, nature there is a policy consideration. Legislature takes many policy considerations into account, including environmental considerations, and decides what it decides. That's uncontroversial. The cases I was looking at, where the courts on their own basically overturn precedent because of environmental considerations, those seem to me more radical cases, more interesting cases, because nature there indeed seems to be acting as a norm. Nature is imbued with legal force strong enough to change the law. So that's the end of my paper. And now, as moderator, I will open the floor to questions if anyone has any. And if not, we can move on to the next paper. Okay, so we will move on then to the next paper, which is Ron Harris's. And if I can find my introduction, let me find it. 1 second. Okay, so Ron Harris, my senior colleague, is the Kalman Lubowsky Professor of Law and History and former Dean at the Faculty of Law, 1 second, at Tel-Aviv University. His main research field is the history of the business corporation, and he studies the business corporation in Britain and comparatively in the wider context of legal and economic history and the history of industrialization, capitalism, colonialism, and globalization. We just heard a bit about these topics in the opening session. And Ron is the author of 3 books, most recently, Going the Distance, Eurasian Trade and the Rise of the Business Corporation, 1400 to 1700, just out with Princeton University Press. Also, Industrializing English Law, Entrepreneurship and Business Organization, 1720 to 1844, and Israeli Law, the Formative Years, 1948 to 1977. And he's currently working on a book project on the expansion of company law from Britain to its global empire from between 1815 and 1914. Ron, please.
Thanks very much, David. Can my presentation be seen now? Excellent. So, as David said, this is not my first project on the history of the business corporation. In the past, most recently, I worked on the formative era in which the joint stock business corporation was formed in the context of Eurasian trade in the around the year 1600. And now I moved forward in time to the time in which the business corporation expanded from Europe, from Western Europe, globally. And this era is roughly the second half of the 19th century and into the early 20th century. As we all know today, business corporations can be found globally, but that was not the case in 1850. So I'm taking a starting point in which company law was confined to a few European and North American jurisdictions and was conceived as highly domestic creation, and moving from it into the era of what's called the first globalization and the creation of the British Empire, or the second British Empire, roughly the period between the middle of the 19th century and the outbreak of World War I. And early in the period, or early in the 19th century, now I'm providing some of the general context in which my company law will be created and expanded. So, and that's a kind of a familiar history, just I want to keep it fresh in mind when moving forward. So in the early 19th century, at the end of the Napoleonic Wars, the British Empire was relatively small after the loss of the American colonies, the 13 American colonies. It was mostly confined to North America, future Canada, and to parts of India. And then over the next century, it expanded massively in terms of exercising military power, exercising claims of sovereignty over large territories, 100, 140, depending on how one counts. And by the zenith of the territorial expansion of the British Empire, it covered significant parts of the globe, about a quarter of the population and a quarter of the territory of the globe. So this is the context. We often focus on the political sovereign military element of the empire, but I'm kind of looking at the intersection between this element and a couple of other elements in the imperial exercise of British power in the second half or in the 19th century. Another dimension is massive migration from Britain, mostly to North America, but to other parts of what will later be known as the white settlers colonies, and the massive migration of capital from from London, from the city of London, globally. And this outflow of capital did not fully overlap with migration or with sovereignty. Much of it migrated, much of it flew outside of the empire, let's say to Latin America and to China. And with this came the expansion of commercial networks throughout the empire and beyond the empire. This was accompanied by introduction of new technologies, such as the steam shipping, new engineering projects such as the Suez Canal, the creation of telegraph network that encompass the world, railroads that expanded in various parts of the globe, in North America, in Latin America, in the Indian subcontinent, in China. And overall, the world have shrinked in terms of travel time for individuals, for persons, and for information or for messages. Now, so that's the general background in which company law is expanded. And the company law is expanded in order to serve all of these developments, not only the political expansion of the British Empire. Today, I'll be focusing on two aspects of this expansion. I'll discuss briefly the policy of company law in the British Empire, or what was the intention of those who made policy in terms of expanding company law. And the second and more, the second element that I'll be explaining more on, spending more time on, is the actual transplantation or migration or circulation of company law from England to the empire. In other parts of this project, which will end up as a book project in a couple of years, maybe 2, 3, 4 years, I'll be discussing incorporation reality on the ground, how many companies were created in different parts of the empire, how stock exchanges were created in different capital centers of the empire, and which multinationals were created in which parts of the empire, and in which parts of the empire did they actually do business. So I'll be discussing all of this in other parts of my project. Now I'm focusing on actual legislation, which initially seemed to me to be the more kind of technical part of the project. The part of the project I didn't expect to find a lot of fascinating, interesting story to tell about. As it ended up, I changed my mind, but only partly, not fully. So, and the kind of project I'm doing here for the book project is not something that was, as I can tell, was not covered as such in the pre-existing literature. I won't get into the details of the literature, but that's the state of things as it is now. As much as company law was studied, it was studied for specific colonies, for specific regions, and not for the empire as a whole. So now I tried to kind of suggest a kind of a theoretical framework for thinking about these issues, a theoretical framework that could be driven out of some of the literature in comparative law, maybe some of the legal history literature, mostly the legal transparency literature. And the way I understand the theory is that some fields of law will be much more, the tendency for the migration of law in these fields of law would be much greater than in other fields of law. And one major consideration would be how embedded is this field of law in religion, in culture, in tradition, in society. The more it is embedded, the less likely it is to migrate, let's say family law or land law, or less likely to migrate throughout the empire. Whereas fields of law that are not as heavily embedded in pre-existing structures, let's say new fields of law, such as maybe commercial law and more specifically company, will tend to migrate more intensively or more frequently. Another dimension of looking at it is what is the perceived advantage of having the migration of law as it's seen by the agents that actually involved in the migration, often colonial officers either in London or in the colonies. So the higher the value of harmonization, uniformity in the empire, the more likely it is that law will be migrating. And again here, there is no obvious advantage in having a uniform family law throughout the empire. There could be an advantage of having a uniform company law in the empire. So in that sense, company law should also be viewed theoretically as a field of law that is more likely to migrate in order to lead for uniformity in the empire. So that's the theory I got into the project with. And as I show, as I move forward, I realize that things are more complicated than this. So this is the common wisdom. If you want to use the best law, the cutting edge law, you'll export the law from London to the various colonies as it is. So it will be mostly from the metropole to the periphery. It might be based on some kind of a colonial office or governmental blueprint that says that one has to, once you annex a territory and turn it into a crown colony or whatever, you'll apply on it specific sets of laws in some fields as this theory postulates. And it's also likely that Brits will not be subjected to the same law as natives in the various parts of the empire. It's easier to export statute law than to export common law. David talked about some of the complications in exporting the common law and some of the advantages maybe from the perspective of the colonists or the imperial center in transplanting, exporting and transplanting statutory law. And terms of priorities, commercial law and company law are relatively high on the blueprint, on the priority list. So what are the organizational, administrative agencies that could kind of bring about the migration of company law? There is a full set of commissions of inquiry. Benton and Ford in a recent book called Our Attention to these commissions of inquiry that were used in the first half of the 19th century. These are somewhat less relevant for me because company law, general incorporation, showed up only in the middle of the century at the time in which these commissions of inquiry were already in decline. For India specifically, there were a few law commissions for India. Later on in the century, there were some colonial imperial conferences starting in 1887. The Empire's Federation movement is another vehicle. I'll say something about it. The Society for Comparative Legislation, about which David has worked, is another tool for this. So it doesn't have to be only something that is being done by the government. It could be done by civic society, by NGOs, various types of associations. So now when I'm trying to see what was the actual policy with respect to company law, it's very hard to pin down the actual policy. There are not many clear statements of what the policy is. One could pick them better in those colonial conferences because their records were relatively well kept. They were public, they were publicized, they were printed. And the sense that we get from mostly those colonial and imperial conferences taking place in the late 19th century, in the last couple of decades of the 19th century and into the early decades of the 20th century, is that British company law was considered to be the most advanced, and this is why it should be exported to the rest of the empire, that harmonization is highly beneficial, and the basis for harmonization is the British model, not any other model, and harmonization is good for business because it facilitates the movement of entrepreneurs, capital, and actual business cooperation. Harmonization is convenient for British lawyers, for British judges. And the main question was, the main open question, the main question that was debated was, to what extent does the center want to compel this on the periphery, on the various colonies, on the settler colonies, on the crown colonies, on the protectorates, on India, whether the center wants to mandate a specific model or whether it just recommends or encourages or facilitates the adoption of this model. And in this context, it came, once one reads the colonial conferences, one realizes that there is a clear distinction between the settler colonies and the rest in terms of what will be the level of enforcement of this privileged model. I'll show some of this. For example, if one looks at the proceedings of the 1907-1911 Imperial Conferences, one can see that company law was relatively high on the agenda, not on the top of the agenda, but definitely high on the agenda. And the Board of Trade in London say that it's the right time for uniformity. And it recognizes that absolute uniformity is not practicable, but one should advance a much greater uniformity in the empire, and there are advantages of this. When one looks at the views coming from the colonies, and it's important to stress that the imperial colonies, the imperial conferences ended up being mostly conferences for the settler colonies, not for the entire empire. India was represented in some of them, but let's say African colonies were not represented here. So let's compare the New Zealand and Australia views on uniformity of company law, and the differences seem to be minute, but they are important. The New Zealand delegation said that it's the best interest of the empire to promote uniformity, more uniformity throughout the empire. In the laws of copyright, patent, trademarks, and companies are the ones that I'm interested in. The Australian delegation says has somewhat different phrasing. It is desirable, so far as circumstances permit, to secure and maintain uniformity in the laws of the empire. So it's not a single law, it's just desirable, and when one gets into the actual decisions, one sees that the Australians did everything they could to prevent actual processes that would compel any kind or any level of uniformity on the Australian colonies. So the devil is in the details. Everybody talks about uniformity. The question is whether they're really committed to uniformity or whether they want to maintain their own self-rule as colonies. And I think that New Zealand, which was the most English or the most strongly connected to the center, and Australia represents two ends of this continuum. I won't get into the actual tools that could be used, and maybe I'll move now to some concrete examples in the remaining couple of minutes that I have. So these are the British company statutes, and the question is which of these were adopted by which of the colonies. And very briefly, British India was following England. Britain was following relatively quickly once a new act was introduced in Britain. A new act was introduced in British India. It was relatively similar to the British one, but the real story in India is the bottom bullet, the managing agent system, which was a system that was introduced, I cannot get into the details, introduced by British business persons in India, and this system in a way bypassed the entire company law system because agents were actually running companies against the grain of company law. It was not the shareholders' general meetings, it was not the boards of directors, it was not the CEO, but rather the agent that ran the various companies in India that were really involved in the big business in which British were involved. So this is one of the examples of how this was done. In fact, the managing agent, rather than the governance of the company, ran the company. I won't get into the details of some of those. Interestingly, if we think of harmonization, it turns that because of administrative divisions, the colonies around India followed India rather than following directly Britain. And when there were deviations in India, they were copied by countries, by colonies around India, not fully depending on the specific history, because some of them were subjected to the East India Company and then to the India office. Some of them were detached from the India office at some point. So one can see quite a mess of disuniformity around India that results from the changing connections between these various colonies and India. With Hong Kong and China, there was a different story. Again, I won't get into the details. The intention here of the British was not to have uniformity between Hong Kong and Britain, but rather to use Hong Kong as a basis for forming companies that will be able to do business in China. And a full set of enactments were introduced in Hong Kong for this purpose. In Australia, there was a following of Britain, but a sense of self-rule often led to deviations from this British model based on circumstances in the Australian colonies. The most kind of manifested example for this is what a specific legislation that was created in Victoria starting in 1871, the no liability companies for the mining sector. Here, the nature was different, but society was different from England. Nature demanded different types of mining. Society was less cohesive, less communal than the one in England. So they introduced new legislation in the form of the no liability companies. Canada had its own story, the connections to the US that David has mentioned before, some unique features that resulted from the structure of the Canadian Federation, some introduction of a system, what's called the letter patent system, that was long gone in Britain and was reintroduced in Canada. The Caribbean colonies were relatively neglected by the colonial office. Many of them did not have any company law, and if they have, they didn't follow closely the legislation in Britain. They introduced one set and then did not re-amend it. East Africa followed India for various reasons. And again, in East Africa, there were calls for harmonization within East Africa, irrespectively of what was going on in other parts of the empire. In the Middle East, there was the presence of the post-Ottoman heritage. The Ottoman heritage in the post-Ottoman period was important in various parts of the Middle East, in Egypt, in Cyprus, in Iraq, and in Palestine in different ways. So different parts of the empire had ended up having different types of laws. If we'll just look at the settler societies that were settler colonies that were represented in the 1907 Imperial Conference, there were 22 different systems of company law, 145 different company pieces of legislation in those settler societies. And there are obviously many more colonies in Britain, in the British Empire, beyond those. So the end of the end product was a real legal jumble, not any type of harmonization, but rather a jumble. So this simplistic story doesn't capture the complicated reality. In fact, various other factors impacted what was going on the ground. The administrative capacities of various colonies, the administrative divisions within the British Empire, the colonial self-rule of some of the colonies that didn't want to follow England, but rather legislate for themselves, local interest groups that have worked differently in different parts, British interest groups. So the end product was really far from, as much as there was the uniformity that was implemented from above, there was a parting from the main model by most colonies for various contingencies and conditions on the ground. And the next stage, just as in a way of conclusion for me, is to understand how was this jumble of legislation was utilized, exploited, manipulated, or arbitraged around by various actors within the empire that were connected mostly to the multinational companies that started, that were originated, established in this period and expanded globally. That will be the next stage of this of the project. So I'll stop now. Thanks, David. I hope that I didn't go over time, at least not too much.
No, perfect. Are there any questions at this point for Ron? There will be time at the end also. Okay, Ron, you could unshare your screen. There you go. And okay, so our next and final speaker, those of you who tuned in late may have missed that Professor Apolloni could not make the session today. She's feeling a little under the weather. So Assaf Likhovski will be our final speaker, and then we'll have some time for Q&A. So Assaf, who's also my senior colleague at Tel-Aviv University, is a professor of law and legal history in our Faculty of Law. He's the author of Law and Identity in Mandate Palestine, and Tax, Law, and Social Norms in Mandatory Palestine and Israel. Those are two books. The second one, Cambridge University Press, 2017. And he's also author of many articles on Israeli, American, and English legal history. So Assaf, please.
Okay, so thank you, David. Do you see the presentation? And do you hear me? Okay. Actually, I had questions to both of you, but I don't want to take my time, so I'll save them for the end of the session. Okay, so the title of my talk is Jurisprudence Textbooks in the British Empire. And actually, I'm talking only about three places, three colonial territories: British India, British ruled Egypt, and Mandatory Palestine. But I think I can expand, the argument can be expanded to other places in the empire and actually beyond the empire to other non-Western territories in the late 19th and early 20th century. So what I'll do in my talk is I'll introduce the project which this paper is part of. It may ultimately end up as a book project, I'm not sure yet. But this is a project which is, I think, broader than a single article. And then I'll briefly kind of try to summarize the paper, the current paper as it stands now. I'll talk a bit about the history of legal education institutions in the 3 territories that I examine, the authors that I'm interested in, the legal scholars writing jurisprudence textbooks, and the books that I analyze in the paper. I identified in this paper and in another paper 3 interesting common themes that I find in all 3 legal systems that I analyze. So I'll talk about these 3 themes, and I'll give you some examples. I don't have time to kind of give you examples, a lot of the examples which illustrates all these themes. I'll give 1 or 2 examples for each of the themes that I identify, and I'll conclude by talking a bit about why I think there are similarities between the 3 places that I examine, also differences, and why I think the story is interesting and relevant for various reasons, not just for people who are interested in history of modern legal thought or the history of the British Empire, but more broadly. Okay, so by way of introduction, let me say that kind of this project started from an article that an English legal historian called Neil Duxbury wrote more than a decade ago about the history of UK jurisprudence, and specifically UK jurisprudence textbooks between the early 19th century and the middle of the 20th century. And Duxbury says in this article that between John Austin's lectures on jurisprudence, which were delivered in the 1830s, but were actually published only in the 1860s, and H.L.A. Hart's work on jurisprudence in Oxford since it began in the 1950s, nothing really interesting happened in English jurisprudence. Maybe Duxbury says Henry Maine, who published his book Ancient Law in 1861, is another interesting development, but the textbooks don't actually mention him that much. And if you read the books, it's just a boring repetition of the ideas of John Austin's analytical jurisprudence. And in the same, I think he's certainly right. You know, I've read some of the textbooks from the late 19th century and early 20th century. Okay, Pollock and Holland and Salmond, and they're really boring. Okay, but the question is, of course, we've got the UK, but what about the British Empire? Is this true for the Empire too? Do we find similar textbooks published in the Empire written by people who were not active in the UK, and are they as boring as the UK textbooks? And the answer that I give in this paper and in the previous one is that I actually think the Empire is more interesting than the UK. And it's certainly not the case that people in various territories of the British Empire simply copied the ideas that they originated in England. So I can divide between, just as Ron did, one can distinguish between the dominions, the white settler colonies, and the non-white territories of the empire. And it turns out that a lot of the legal scholars that we tend to think of as British were actually from New Zealand or Australia or other places. Salmond, for example, came from New Zealand and actually began his career in Australia. But I wasn't that interested in the dominions. I was more interested in India. And actually there's an article, a forthcoming article, which is about the history of jurisprudence textbooks in colonial India. And hopefully it will come out sometime in the next few months, but it's already available on online databases such as SSRN. And basically in that piece, I had a short section at the end saying that the developments that I saw in India occurred elsewhere in the empire, but during the revision process, the reviewers of the article said that this part of the article is not really well developed and I should delete it. And I indeed deleted it. And the second paper that came out of this project is actually a response to the reviews. What I do in the second paper, which I'm talking about today, is showing that this, in detail how the features of the textbooks, that the Indian textbooks, also appeared in the two other territories that I examined, in British Egypt and Mandatory Palestine. And basically, for each territory, for each of the three territories that I examined, I analyze 3 books and find these 3 things. It's all about 3, the magic number. Okay, so the 3 unique features that I find in the works that I analyze, the 3 unique and interesting features. Of course, we can argue about the definition of the term interesting, maybe in the Q&A. But one interesting, at least for me, theme that I found is that unlike English works, some of the works that were produced in the empire were far more mixed, in the sense that they're far more open to continental jurisprudential theories. Some of the people writing textbooks in the UK, for example, John Austin, were actually educated in Germany, but from a certain point of time onward, they forgot about the continental connections. But that was not the case for the empire. And it's especially interesting if you look at textbooks from the beginning of the 20th century, because what you find in the continent is really this flowering of really interesting sociological theories about law, both in France, in Germany, also in Russia. And you do find them in textbooks in the empire, and you don't in the UK. So in the empire, people were more open to state-of-the-art, really interesting sociological theories about law, in a sense, far more than they were in the UK. Second thing that I found is that a lot of the authors that I examine, often when they outlined the English theories, they actually criticize them using local examples taken from religious or customary law in India, Egypt, or Mandatory Palestine. So they were critical. They didn't just follow what the English were doing. They were critical, and they were critical using local examples. And I think the most interesting feature that I identify is that especially the local authors, the non-English authors in the 3 territories, were influenced by cultural nationalism and were attempting in their textbooks to insert their own indigenous normative systems, whether this is Hindu law or Islamic law or Jewish law, into the general framework of Western jurisprudence, using a non-evolutionary perspective. So as we saw in the previous panel, in the turn of the century, comparative law and jurisprudence saw non-Western systems as representing a lower stage of evolutionary development. But the authors that I analyzed actually argued that for various reasons, their own indigenous systems were in some senses even more advanced than Western legal systems, and there were interesting jurisprudential insights that could be learned from their own systems, and they were trying to create a sort of global discourse about the nature of jurisprudence in which their own legal systems and they would play a role, despite the fact that Western thinkers weren't that interested in their systems. Okay, so let me talk a bit, kind of set the background, talk about the legal education institutions, authors, and books that I analyze in paper. First of all, I should say that there's a really interesting history of imperial legal education institutions, a global history which hasn't been written yet. So across the empire, you see, especially in India, but later also in other places, you see the emergence of Western law schools teaching a mixture of English and local law. And this can be India. So I've got 2 examples where the authors that I study actually taught. So one example is from the left-hand example is the Law College of Punjab University. The right-hand photo is the Law College of the University of Calcutta, which was basically the intellectual hub of British India, and was a very interesting institution. But there were similar, India had a very well-developed system of formal legal education. It was certainly bigger than what we had at the UK at the time. But in the 2 other territories that I'm interested in, we can see similar institutions. So In Egypt, for example, a modern Western law school is established in 1868. Of course, we've got Al-Azhar, which is an Islamic university going back to the Middle Ages, but a Western-like institute of legal learning is a result of the middle of the 19th century. It's called the Khedivial, and then the Royal, and the law school, and then the law faculty of the Egyptian University, later the Cairo University. You can see it on the right-hand side of this picture. And there were several phases in its history. It was first dominated by French law and French professors, then by English professors, and ultimately was Arabized when the Egyptians took over. And we also have similar law schools in Mandatory Palestine. We actually had 2 or 2.5 of them in Palestine. One was an institution established by the British in 1920, the Jerusalem Law Classes. This is this institution. And there was another institution called the Tel-Aviv School of Law and Economics, established 15 years later. This is the primary school where the institution was, which was basically an evening, based on evening classes, where the lectures were carried out in the 30s and 1940s. So there's an interesting institutional history of legal education that one can tell. But there are also legal scholars working there. So in India, I'm looking at 3 basically textbooks. One by an English professor teaching local law students. This is William Rattigan. You see his picture. And his book was called The Science of Jurisprudence, chiefly intended for Indian law students. The first edition was published in 1888. He was born in India, studied law in the UK, but also in Germany, and then returned to India, was active as a lawyer and also as an academic. In India, went back to the UK, served in the English Parliament, so he has an interesting biography. And I analyzed 2 additional books by Indian law scholars affiliated with the University of Calcutta. Rattigan taught in Lahore, in the Punjab. But Basu and Priyana Sen were 2 Indian scholars. Both gave something called the Tagore Law Lectures, which were kind of a series of lectures at the University of Calcutta College of Law, where people sometimes just described, gave doctrinal surveys of Indian law, but sometimes, especially since beginning in the early 20th century, gave lectures which were more theoretical. So Basu gave lectures basically describing in great detail continental and American theories of law, which you don't find in comparable English texts from the early 20th century. And Sen wrote a book on Hindu law using concepts taken from English and continental jurisprudence. In India, my paper analyzes 3 legal scholars, again, 1 British and 2 local ones. The English legal scholar is Frederick Godbey. His book was called Introduction to the Study of Law, a Handbook for the Use of Egyptian Law Students. First edition came out in 1910. And there were 2 Egyptian scholars I'm interested in. There's actually several textbooks, but I focus in this paper on 2 of them. One by somebody called Muhammad Kamil Mursi, who later was the Egyptian Minister of Justice. His book was called Usul al-Qawanin, which can be translated as Jurisprudence, published in 1923. And Abdul Razak al-Sanhuri, which is a great Egyptian and actually Arab legal scholar of the 20th century, the great codifier of Islamic law for a modern legal system. He has another book, another jurisprudence textbook called Usul al-Qanun, which was published in 1941. And in Palestine, again, I've got 3 people. So I'm using Godbey, who moved from Egypt to Palestine. I'm using the 3rd edition of his book, which was published after he moved, as my kind of example of an English scholar teaching local law students. And then 2 Jewish law scholars working in mandatory Palestine, somebody called Daikan. 2 of them, both of them were Russian scholars, studied in Russia and then immigrated. So Daikan's book, Torat HaMishpat, Jurisprudence, was based on lectures delivered in the 1940s. The book came out after Israeli independence, not the first year after Israeli independence in 1949. And Baruch Gankin, a totally forgotten figure, who wrote a really interesting book called Torat HaMishpat 2, Jurisprudence. Here is his picture. He looks sad, and his life was really sad. I don't have time to go into the biographical details. maybe in the Q&A if somebody is really interested. Okay, and just to illustrate, so I'm talking about these people, but I'm interested in the ideas. So here are the three themes that I identified, and here are examples from the textbooks that I analyze. So the mixture of English and continental legal theory. So Godby's book, for example, in the introduction to the book, Godby was an English, okay, 5 minutes, an English law scholar, but was very familiar with French legal philosophy, jurisprudential works, because he was teaching in Egypt, where the legal system was based on French law, the modern legal system. He says continental writings upon legal theory are newly neglected in English law schools. It is my hope that this book, though primarily written for law students in Egypt, may perhaps induce some would-be English lawyers to read the works of French legal theorists, and he has a series of theorists who are not mentioned in UK textbooks at the time, and which he discusses in great detail in his book. I've got another example, or actually another person taught jurisprudence at Tel Aviv, the Tel Aviv Law School, whose book I don't analyze, but it's such a great example that I need to share it with you here. So this is Max Lazarson, a Russian scholar, moved to Latvia, then to Palestine, ended his life as a professor at Columbia University in New York. And I took this is a picture of part of the syllabus of the course of jurisprudence that he taught at Tel Aviv in 1939. So the syllabus ends with a list of additional sources that the students can consult. So he suggests that the students read a book of his in Russian, which came out in Riga in Latvia in 1930, Obshaya Teoria Prava, General Theory of Law, 2 works by English more familiar English legal scholars, Salmon and Pollock, 2 books in Hebrew, one by Lazarson, another one was actually a translation of a Russian work by somebody called Josef Pokrovsky, and then a German, but also Nazi legal scholar called Justus Hedemann. So, you know, the students, Lazarson was a polyglot. Apart from these languages, they also published in French, in Latvian, and in Yiddish. Okay, so I don't expect that many of the students were able to read all these languages, but it's a nice illustration of the mixture of sources that you don't find in the UK, but you do find in Palestine at the time. Okay, I don't have a lot of time, so critique of Western theories using local examples. So Rattigan's book is an example. We've got, he criticizes both Austin and Henry Main for saying that their theories do not fit the reality of law in India. Both customary law and also Hindu law do not fit the definitions or historical story told by English scholars. And I don't really have time to go into it. And cultural nationalism, this is just one example from Sanhuri's 1941 textbook. He says there we must Egyptianize jurisprudence freed from French occupation and contribute to advancing global jurisprudence by sharing the light of Islamic law with the rest of the world. So what he says is I'm teaching the Western theories, but I'm telling my students, look, a lot of what I'm teaching actually you can find in Islamic law, and actually there are some ideas in Islamic law that are more interesting than what you find in Western theories, and we should share the light of Islamic law and its theoretical ideas with the rest of the world. This is our task as Egyptians. Okay, so I'm concluding. I don't think there was much influence between these territories. I think the similarities that I found were the result of the encounter of Western legal theories, which was supposed to be universal, but were actually had a better fit with Western law, with the legal reality of colonial legal systems, where you've got customary law, religious law, and often a mixture of norms and institutions taken both from continental and Anglo-American law or English law. And also there's an influence of cultural nationalism in all these 3 territories, and actually in many other territories in the non-Western world in addition to these places. And cultural nationalism leads these people to try to show the relevance of local law to Western jurisprudential discourse. And there are also differences. In India, there's more English academic influence. In Egypt, it's more French. And in Palestine, because we've got emigre East European Jewish legal scholars, you find many examples and theories taken from, say, late 19th century Russian jurisprudence. And I'll end by saying that I think the story that I'm telling is interesting, not just because some of the people that I discovered have really interesting biographies, but it's the first step into creating a non-Eurocentric history of modern legal thought. There are areas of law, for example, international law, where for more than a decade, people have been trying to write a truly global history of legal scholarship, the legal scholarship of international law. The history of jurisprudence is still very Eurocentric or Western-centric. There's nobody knows about these people, or if people write about them, it's usually within national historiographical frameworks. And I think just as people have done so or are beginning to do so in the history of international law, one should also write a non-Eurocentric, a truly global history of jurisprudence. And this is the first stepping stone in this process. So I'll end here. Thank you very much.
Thank you, Assaf. So now I'd like to open the floor to questions. If anyone has a question or a comment, I guess you could just raise your hand, or you could just jump in.
I actually had questions.
I do too, but I should tell everyone that we live near each other, but I haven't seen Ron and Assaf in person in quite a long time because we're in lockdown here. But so Assaf, let's first see if anyone else has one, and then so okay, you could break the ice, Assaf. Go ahead.
No, but I see that Christian raised his hand.
Oh yes,
so,
okay. So Chris, sorry, I missed that. Go ahead.
Oh, sorry. Yeah, I'm sorry to break up the neighborly chat.
Yeah, exactly.
One of the ways that I noticed all three speakers structuring your talks was primarily by geography, and there were occasionally hints that there might be also differences based on time period. But I was wondering if you could elaborate on that. So, for example, when it comes to transplantability of company law, was the main driver differences between, say, Australia and New Zealand, or were there also differences based on when these places were colonized and on when the conversation was happening? And then part of the reason I'm asking this is a lot of the work in the British Empire sort of assumes there's these phases. So if you think of Karina Monsina's work on Henry Maine, for example, she argues for this big break after the 1857 rebellion between sort of liberal assimilationism and culturalism. And so I'm wondering if you see sort of similar kinds of effects in the areas of law that you're looking at as well.
Okay.
Ron, why don't you start, Ron?
Hi, Christian. Thanks for the question. So I'm sure that once I already started looking at the business corporations themselves, the multinationals, and their things are much more fluid, and they are not confining themselves to kind of the administrative divisions or to regionalism within the British Empire, but rather floating around capital and business based on the sector of their activity or the technology that they are using. Let's say in telegraph, you can see the same company moving around freely around the globe. But I try to respond with respect to company legislation. So I was looking, for example, for differences between commercial hubs and settler societies, some sort of functional differences of this sort. I didn't identify any so far. What you can see is that basic kind of debates within the British Empire about the level of federalism that is desired within the empire. And these debates about the level of federalism, as opposed to self-rule, for example, or to total disintegration, this can be reflected in various parts of the empire, in various debates about legislation, but they reflect themselves mostly in the settler societies, in the settler colonies, because there are opportunities for these divisions to emerge, and there are better records that actually capture these, and you can observe them thanks to these records. As much as there were such cleavages in other parts of the empire, I didn't identify them so far.
Okay, David? I would just say that unlike Ron is kind of longue durée, kind of looks at long time periods. I'm more focused on actually my main interest is 2 or 3 decades in the early 20th century. India is has a well-developed system of formal legal education already in the late 19th century. But most of my interest is kind of in really the first 2 or 3 decades of 20th century. And there, what I see is kind of actually a jurisprudential wave which sweeps the empire, but also other places like China and Japan too. And the same thing occurs in all these places. So I'm interested in this similarity. There's this time period where suddenly you see the flowering of institutions and also textbooks, theories, legal scholars doing something similar all across the globe. Okay, so it's I do talk about the late 19th century, but I'm mostly interested in this really interesting period of the early 20th century. Obviously, you've got the same thing in the West: sociological jurisprudence, German free law, the social in France, and people have been aware that kind of it occurs in the West, but everybody who's talking about it, talking about the non-Western world, only sees influence and copying of ideas rather than something really original that's occurring there, which I do see in the textbooks that I analyze.
So I'll just add, it's a great question, and I think my paper has very little chronological layering. That's partially just a limitation of the sources. The cases I found are all in the written paper. I mean, I don't think there's a lot more out there. And so I took what I could find, and there's not a lot of development over time that I could see. One thing that I noticed that I don't have a good answer for, though, is why India becomes, in most of these issues that I looked at, India is a major player, but comes to the debate late. So like late 19th century, early 20th century, you start seeing Indian cases in pretty much all these issues, but not beforehand. Whereas, American cases you see much earlier. Now, there was lots of law reporting going on in India already, from earlier in the 19th century, but I haven't seen cases on these kind of topics at this point, and I don't know why.
Thank you. No, I enjoyed all 3 papers. So thank you all 3 very much.
Anyone else? Assaf, you could ask your question in the meantime.
Okay, so actually, this is very interesting, and I heard these papers in some sense I heard them in some sense before, but kind of they are more developed now, and also this is an opportunity for us to discuss them in this kind of forum too. So David, my question to you is, you identify this kind of some courts that kind of talk about following the common law, and some courts talking about the local environment as a reason to create new doctrines which are different than the common law doctrines, but kind of we don't get any sense of why certain courts did something this way or that way, and there's no kind of, apart from identifying the fact that kind of there were these 2 modes of dealing with a different environment, there's no attempt to generalize and say something about the reason for the difference between the different territories. So that was my question to you. And the question that I have to Ron is, in this kind of, I saw this presentation before, and there was more information about capital flows and the history of kind of global capitalism there. And obviously the question that kind of economic historians would be interested in would be, what is your position on the relationship between law and development? Are you arguing that kind of law facilitated in some way in the expansion of English, commerce, industry, capitalism in the empire? Or it seems as if you're arguing the opposite. The mess that was created by the difference between the different sets of company laws in different British territories was actually a facilitator. So this is kind of the argument which is opposite the usual argument about that law and development scholars are making. What you're saying is that British Empire because, oh, I don't know what this is. Because the British Empire was such a messy place, people, the multinationals could use, the difference could utilize it. Law is a hindrance to economic development rather than a facilitator. Or maybe you're not arguing this, I don't know. Anyway, that's my question.
So I guess I'll go first. Yeah, my paper is conspicuously lacking in any kind of social or political context for the court decisions that I look at. I'm really just focused on the judicial rhetoric. And partially it's because I didn't do the research on the context, but partially because I don't want to. I mean, that would be a book project, I think, to sort of tease out the differences and similarities and why it happened different places, different times. But one thing I noticed, I mean, what I tried to do by juxtaposing different jurisdictions is showing that there's something going on here across the board in all these places. So it happens in 18, the first decade of the 19th century in Pennsylvania, and it happens 100 years later in Madras. So, it may not require that the kind of deep context that one would normally want. I'm just sort of trying to do a shallow but wide study here, but you're absolutely right.
I think that you captured the kind of a transformation that I'm undergoing as this project develops, Assaf, in the sense that my initial intuition, based on kind of a relatively basic theory, was that somehow the British harmonized the empire, and by harmonizing a system of company law, facilitated the ability of entrepreneurs and capital and corporations to move around freely in the empire, take advantage of Britain's superior position globally, take advantage of the magnitude of the market, and take advantage of the fact that they were able to solve some of the basic problems in the let's say agency problems or whatever in the company legislation of the mid-19th century. So this was my initial intuition, but now I think I tend towards the way in which you portrayed my position just a couple of minutes ago, which is that these business corporations enjoyed the fact that there was a governance vacuum that was created in the empire. And this governance vacuum that did not exist in previous centuries, in which the relationship between the empire and commercial interests or business interests was much tighter. So this vacuum allowed multinational corporations to manipulate the system, to find ways to arbitrage, to select the organizational forms they want, the kind of privileges they want, the tax regime they would like to apply to them, to do some sort of form shopping when they had to litigate disputes. So I'm now tending more towards this version. It's not yet my final argument in the project, but that's my current kind of position.
I thought there's a question in the chat. Actually, there's two questions, but I think actually they're both, the first one's directly to you and the second one is for anyone. Well, if there's someone in the audience who wants to answer the second one, you're welcome to, but I think Assaf is probably closest to it right now.
I'll unmute myself. Okay, so the question about the textbooks. So this is actually a really sad story. So I was interested in looking at India. I actually wrote about the history of legal education in mandatory Palestine a long time ago, and I came across some materials about Indian legal education in the colonial office, where they basically said the empire was divided. Part of it was run by the India office, part of it by the colonial office. And in the colonial office, they basically tried to emulate or copy or imitate what the people in India were doing, because India had such a well-developed system of legal education. So I knew for a long time that I was interested in writing about India legal education, also legal thought. So then I spent some time in London, and I went to the British Library, where we've got the materials of the India office and also printed sources. And I photocopied like crazy. And then I discovered that most of the textbooks are actually available online in archive.org. So I wasted a month. I had back problems. It was horrible because all the materials, or most of the materials that I photographed were actually useless. Somebody scanned all the stuff beforehand. So they are available. It's kind of like 19th century and early 20th century textbooks are all online right now. It's easy to get them. Some of the there are some interesting materials from the kind of, archival sources that are also only in the British Library, but most of the stuff is available all across the world. Okay, so that's India. Egyptian works are also available online. Works from Mandatory Palestine, I actually photocopied they're still not scanned, and I photocopied them in libraries in Israel. About French law and French legal tradition. So basically the Egyptian codes of the 19th century were copied from France as they were in other places. So for example, think about Egypt was kind of semi-autonomous. It was supposedly a province of the Ottoman Empire, but there was a semi-independent regime there. So in the Ottoman Empire too, basically French law, French codes, which were considered the most advanced in the 19th century, were copied. And so there was French influence there. Problem was that the British at a certain point became the dominant rulers of Egypt. Both the British and the French occupied Egypt together when the Egyptians couldn't pay their loans, but the English became dominant, and they kicked the French professors out of the Royal Law School, the Khedivian Law School, and then they were kicked in turn by the Egyptians and the school was Arabized once the Egyptians became independent. Egypt became independent in 1922. Okay, so there was French influence, partly because of the prestige of French law, just as American influence now spreads around the globe because of the prestige of American culture. But at a certain point in time, the English became dominant, both politically and legally. So it's a very interesting system. You've got English professors teaching law, which is based on French law. Okay, another question for me. So this is from Benjamin. Yeah, there's actually, so just as the history of legal education in the British Empire is now beginning to be studied, there's actually a research group which has been working on the history of legal education institutions in the French Empire. This can be Algeria, this can be Indochina. There were also institutions. There was a French law school also in Cairo, and there was one in Beirut. Okay, so there's a research group which has started working on a topic 2 years ago. It's people from the University of Bordeaux, and I forgot the third person who is responsible for that. I can send you the details. They've done they had 2 workshops already, one on the institutions, the second one on the biographies of people teaching them there, and there'll be a third one on the legal ideas produced in these places. But you see an interest, kind of the same kind of interest in reconstructing the history of legal education in the French Empire, which resonates or echoes my interest in the British Empire.
Anyone else on chat, or you could just jump in with video if you want? In the meantime, Assaf, I'll just say that I think the Khedivian Law School is a topic that needs to be researched as well. I just know from my research on history of the Society of Comparative Legislation, a lot of the heads of that organization or the people active in it, also you mentioned Godby, but also our own Norman Bentwich, also Frederick P. Walton, who was the dean of McGill afterwards.
Amos.
Amos, right? I mean, so many people came out of that, were at least on the faculty of that law school, and then sort of spread around the world.
So I should mention a wonderful book which focuses only on Egypt, and I learned a lot from it. This is by somebody called Leonard Wood, who was educated at Harvard, and the book came out about 3 or 4 years ago. And this is basically about the history of the legal education system of Egypt, and also about textbooks produced in Egypt from the late 19th century to the 1950s. It's a wonderful, wonderful book. It only focuses on Egypt though, so that's the kind of, it doesn't kind of compare Egypt to other places in the Middle East or in the British Empire, but it's an excellent book. Leonard Wood.
Okay. Yeah, Assaf, could you type the title?
Yeah, it's called Islamic Legal Revivals, I think. Let me just kind of get the Amazon webpage.
And David, can I ask you a question about your project?
Sure.
So how do you see the changing division of labor between the common law and statutory law as you move from one natural environment to another within the Greater British Empire? How do they, whoever is there on the ground, conceives this division of labor, or the need to rethink the division of labor between statutory law and case law?
Yes, that's an interesting question. So that's a much broader question than what I was looking at. I don't know. I don't know, other than to, I mean, I would say that over time, across the board, there's more legislation. And so the sort of the province of case law shrinks and the province of legislation grows. I think that's pretty much everywhere. Is that phenomenon geography dependent? I just don't know. I would suspect, so I mean, you know, all the things you talked about in your talk, you know, about how law gets made in the colonies, it's partially a question of capacity. I mean, every colony has at least one judge, as far as I know. And obviously the legislature as well, but the capacity for legislating, I think, in many colonies, especially the smaller ones, is highly limited. You know, if all they can do basically is copy from a text that they're given by someone else. But whereas, you know, you have places with very advanced legislative bureaucracies. So there may be, I would guess that there's a connection between the size of the colony maybe and its wealth, and the amount of legislation, but I don't know if I would guess that there's one that's related to geography or environment. That's my guess. Okay, so Jess says we're out of time. So we're going to break then. So thank you to my fellow panelists. Thank you to Jess for setting this up. And thank you for the questions. And if anyone has any further questions, I'm sure we'd all be happy to hear from you by email or whatever. Thank you all.
Thanks very much for